right, well, we're at 1:02 here, so I think we can get going. We have 15 people on the call, and I expect a couple more to trickle in. So, good afternoon, everyone. Thanks for joining us today. For those of you who don't know me, I'm Zach Dobbin. I'm the program manager of the Southern California Energy Innovation Network. And today I'm delighted to introduce our guest speaker, who's done a phenomenal job of helping us put off this 3-part workshop series on IP specifically for clean tech companies. This is the second session of 3, and our next session is going to be next Wednesday. So I'm going to let him jump right into it and introduce the topic. So without further ado, Miku, if you could please share your screen and jump right into it.
Great. Hey, thanks, Zach and Shannon and Marty for letting us do this. Yeah, I believe you take questions in the chat, right? Is that how it works? We'll address those at the end because some of the materials might answer the questions. But the way we would design this, and I'm gonna share the screen right here, is that there'll probably be around 12 to 15 minutes for Q&A, depending on how long these slides take. Thanks again for your time. You're able to see the slides now, right?
Yes, we can.
Okay, terrific. So I'm Miku Mehta. Maybe you remember from last week. I'm a patent attorney dealing in the patents and IP on these areas. Last week we talked about the types of patent strategies and invention capture and things like that are unique to clean tech, some of the issues and strategies. This week we're going to talk about what VCs might want to see in your patent portfolio, and it's more of the types of questions they ask and how you can give them, and it's just investors generally, as much confidence as you can, and also at the same time make sure you're all taken care of in terms of the risk protection and things like that. So couple of things, like, why is the IP important? It's important to be investing in a company that can demonstrate innovation with new technology, and if you are able to obtain a patent, or if you have a patent filing strategy, those are ways to demonstrate your technology leadership, which can put you ahead in terms of sales and market. Also in industry, it's important sometimes to be the leader and have the patents and force everybody else to have to design around you. It gives you a little bit more breathing room in terms of competitive pressure in the technology. It carves you out some space. Also show risk management. It's important to be able to have investors understand that you're protecting your market and you are pushing back competitors with a fairly sophisticated strategy, such that if they invest in your company, they're not going to all of a sudden get a letter from somebody else accusing your company of patent infringement. And if you do, you know how to deal with it, and you've got a defensive portfolio. And then show the protect proprietary aspects. What that means is there's some IP that's trade secret, there's some that's patent. Knowing what to protect and what not to protect is important. Anybody can put together a slide deck and file a patent application. It doesn't mean you're going to get a patent. It doesn't mean that what you filed necessarily has value other than being patent pending. But when you can show investors that this isn't just a filing that was submitted, you know, a provisional application, you can file your birth certificate if you want. It shows that you've actually taken the thought to protect the proprietary aspects and not just do a brain dump to the patent office. And then provide valuation. Sometimes it's license streams. Sometimes it's to prevent price erosion. If you don't have a patent and you have a lot of competitors that come quickly, even if they can't produce the same know-how and quality, they can cause price erosion, which hurts the margin and, you know, makes it harder to get a bigger ROI. So that's some of the high-level reasons why IP can be important. what are the clean tech specific issues that you face? Well, in other areas, other technologies, sometimes it's easier for companies to explain to their board or their investors the nature of the IP because it's in a singular technology. But clean tech is actually fairly complex. You have diverse technologies. You're dealing with things like materials, sometimes thermodynamics, sometimes electronics, control systems, hydrology and geology sometimes, and then you're also dealing with policy. You're dealing with carbon capture. You have competitors and collaborators that go across industries. It's not as easy to carve it out and say, this is our industry. That's part of the struggle is that, when somebody says they're a clean tech or an energy technology company, aren't they also a software company? Aren't they also a high-tech electronics company? It's not as easy to define. The business cycle, in many ways, is more variable. There are some parts of it, like the app or a control system, that would have a shorter life for that iteration. And there are some more infrastructure and platform and grid level innovations that have a cycle of decades sometimes. The initial capitalization also varies. To make an app and sell an app, you just need to program it up, right? But to actually make a prototype, test a system that works for some of these technologies requires a greater upfront investment. And if you have IP on that, then your investment is protected from somebody splitting off from your company and trying to copycat you, or somebody finding out about it from a meeting and then just trying to quickly ramp up based on piggybacking on your innovation. You also have customer confidence. The last couple of points, it's just customer confidence and supply chain. But basically, you have to consider that you might be in different points in the supply chain. So it's not as easy as some other technologies in terms of having a well-bounded solution space or a well-bounded business categorization. So what kinds of questions might we get? These are just some basic questions on IP protection. So how are you protecting? Show me the patents that protect your core technology. Did you file provisional or non-provisional, and why? Did you choose utility? Have you considered design for your ornamentations? Is it pending or issued? A lot of startups say, oh, well, we have patents, but no, you have pending patents. They haven't been issued yet. So if you tell somebody that you have patents, that's not the same thing. And then who owns the IP? Have you got the chain of title right? Have you assigned it to the company, or do the inventors have it, or is it assigned to individual founders? I've seen all three come back to really hurt or help in different situations. So for your IP, somebody might ask, so I know this is your invention, but are you thinking about just a singular product? Or are you thinking about like a business strategy in terms of license streams, non-intuitive use cases? Can you name some potential licensees and how you would license to them? And then finally, how are you managing the process? How much are you paying per patent? How much are you paying per application? They probably want to know that you're not spending nothing and getting nothing, and you're not also disproportionately investing in IP relative to your overall business. So about defense, in addition to the overall filing strategy, a question will come up. So have you cleared the risk? What's your IP strategy for patent trolls, competitors, or collaborators? If you get approached with somebody who wants you to cross-license, you get approached by a troll who wants a license on your product, if you get approached by a joint venture, whether it's a university or another company in the space, what is your IP strategy? If you collaborate, who owns the IP if two companies are collaborating? It's important to know this up front, because if you're co-owning IP, that's a very dangerous thing, because each party owns all of the IP, and if things go sideways, then each party has a full right to give a royalty-free license despite the objections of the other party. Second point, do you have freedom of action? have you actually done a patent clearance? Have you gone around and looked at the patents in the space and make sure you're not violating patents? What's worse than investing in a company, having a product release, and then a few days later, getting a letter from a patent owner saying, what you're doing is exactly what we patented years ago. We want you to stop, and we want you to pay a license. Then, and they go very public with it, right? So that's, and then what if you do get a warning letter? Do you have some idea how you would react? I've seen companies that actually get into email communication with patent owners on these warning letters, and this is not privileged, and maybe it's not even for settlement purposes, and it can later be used as an attachment to a lawsuit saying, a publicly filed lawsuit. And so, when you get a warning letter, you have to be very careful about how you handle your reply. Some metrics that some investors use. These are just examples. There's, I think that the two at the bottom are most interesting. There is software that allows one to score patent quality. It goes through, looks for things like typos, grammatical errors, but it also looks for legal issues where you've used terms inconsistently or you've not drafted a claim properly. Most firms, including ours, we use that kind of software to evaluate the quality of our own drafts before we file them. So investors can also use this, and they can see, are these patents, high quality? If the exit strategy is M&A, and some big company is going to run these through a analytical tool, you don't want it to come out and have some, embarrassing language in there. There are horror stories of patent applications that have been filed where there's a big open space where it says insert something here and it was never inserted. So you have to know that investors have ways of finding this out without having to pour through the patents, and can quickly just give it to their admin and say, get me a score on their IP or get me a score on their patents. And then the last one, patentability opinion on prior art search. Do you think you have something novel? Do you have an independent opinion of it? I'm not saying that you have to go out and do a search or find art. We already talked about that, but last time, you have to make a decision on whether you want to be exposed to the patent or not. But sometimes there are questions on that. So what I suggest, part of it is how you communicate and explain that you have a sophisticated and medium long-term policy that explains all of these things. I suggest you take all the approaches that are appropriate for you, but what we do is when we work with our clients, we make a big patent map. It's like a big jigsaw puzzle. We slice up the technologies and we mark them as foundational, improvement, open source, public, etc. And then we mark it with the filing stage, how much it has been spent, all of that. And we update that quarterly. And it's like 4 tabs in a big Visio. And you don't have to get into that level of detail, but you should have some program. And this is an example. So first you want to protect 2 things, or really 3 things: your foundational technology, your core technology, but maybe not disclose the secret sauce because you want to keep that as a trade secret. Consider detectability and enforceability of the patent. And then anything that you are going to disclose in public, file it before you disclose it. It's okay to file in stealth mode because patent applications aren't published until 18 months after the filing date. So that's an important thing to keep in mind. So that's typically, what your first phase, and it's easy enough to come up with an executive summary so that if an investor will ask you, what's your strategy? You can say, well, I'm first going after these technologies, and you can explain whatever is relevant of something like this. Then second, as we go more into the prototyping, we find out more about the improvements and use cases, how customers are buying and using your technology, what kind of modification and design arounds can avoid your patents, and what kind of other license streams may be out there. I found, like, for example, with batteries, if the space might be in automotive, but it might be in home battery storage. There are license streams outside of your intended use and your intended market. And if you get that in your patents, it can increase the valuation because somebody else might need to take a license or might want to license or purchase your patent at some point. Then I also say, think about the other areas. Are you documenting open source in your open source license agreements? Are you part of any standards bodies? That's more on electronics, but sometimes you will find if you're in the automotive space with some kind of electric vehicles, you're into some kind of standards. And then trademarks and designs, which are not your typical patent aspects. Make sure you've got that covered. This tells investors you've protected your brand and you've clearly defined what is public and non-public, so they know, yes, we're using open source. We're not wasting our time to reinvent the wheel, right? And finally, global. You're good for the US, but let's say you have some kind of product or it's easily replicable. You may end up wanting to go into foreign markets. You may have parts of your supply chain that are overseas, and you want to be able to have trusted suppliers with know-how and quality, but you want to protect them from knockoffs. Price protection, again, we talk about price erosion, and then license and defensive options. Global is very expensive, which is why I put it at 4, but you do want to think about at least filing international application and maybe going for the big IP countries, EPO, UK, China, Korea, Japan, and then some of the bigger population markets in ASEAN, India, and others. But this requires a lot of pricing and budgeting and planning. So keep that in mind. I'm not sure if I showed this last time, but under global, this was just finishing up some of the last one, but here is the patenting hotspots. In Asia, there are a lot of filings in Korea, China, and Japan. And then you can see in US and in Europe, there's quite a bit. Saudi Arabia, India, Australia, and Brazil. So this is consistent with patent filings generally. It's not inconsistent. So I'm not sure there's any difference between regular patent filings and green patent applications, except maybe Saudi Arabia and Australia. So last one is just things to think about as you go through global patent strategy. Where do I want to file? The question is where and how much do I want to pay and what's the value of it? You're probably not going to get that detailed of a question on that, but if you do have an important customer in an overseas market, you definitely want to make sure you've got that market locked up, because the last thing you want is someone to come in and just replicate what you did, and you have no protection because it's published, it's only patented in the United States, and you're basically competing with someone else on their own home turf with what has become commoditized by being publicly disclosed without protection. So you want to be careful about those kinds of things. But as you get into those business phases, you'll be able to discuss that. That's not imminent. It's just that you need to be aware of that. And in some countries, you need to file before you have any publication whatsoever. So yeah, so this was just kind of an overview of the general space of what an investor might want to know. At this point, I think we're ready for Q&A, Zach.
Yeah. Perfect. Thanks, Miku, for another great presentation. I'm going to address the first question in the chat here from Marcus. So Marcus wants to know, when you have pending patents, do you provide a copy of it to investors after they've signed an NDA?
Yeah, investors want to see those things. You filed it, so from a patentability perspective, they cannot, get in front of you in line. But the thing I would say to be careful about is, yes, after they've signed the NDA, we can provide them with the filed IP, but be careful about other things that you provide to investors that are not included in the patent application. What will happen is you file a patent application, A month or two goes by, you do some more innovation, and you provided the patent application, but you also had some new slides or some kind of a demo, or maybe it's a kind of a simulation or something, and that was not in your patent application. So be aware that if you're providing new things that are not in your original patent, it's not too expensive to file a provisional with those items in it, just to have kind of safety, belt and suspenders, whatever they say. But yeah, they typically want to see that, because if they can't see the patent applications, it's very difficult for them to assess how strong your IP is.
Thanks so much, Miku. So I'll remind everyone, if you have a question, you can feel free to unmute yourself, raise your hand, or post it in the chat. So it looks like we have a question from Verof. So Verof, you just want to go ahead and unmute yourself. You can ask your question if that works.
Hey, thanks a lot for the presentation, Miku. Overall, really great context. Just one question about the investor IP metrics. So is this a pretty standard product that most IP law firms provide? Is it like basically they just plug in a bunch of your patents and then spits out a number? Could you just provide a little bit more context for how this actually works?
Yeah. So this is my list of examples. You're talking about slide 5, I believe, here, which I'm still showing. So
yep.
This is what I recommend that you be prepared to explain to your investors. Some of this information, and I typically will keep this in an Excel spreadsheet. Each client will meet once a quarter, or maybe a couple of times a year, to talk on all of these topics. And when we meet, we have this in the spreadsheet, and we update the spreadsheet for our clients. It's not a software tool like the first 1, 2, 3, 4, 5 bullets. That's not a software tool. And a number of trade secrets, we typically don't write that down. It's just that you need to be able to, to have that on your own. But, we keep a budget tab. We keep a tab with the provisional number, the number of claims you have, if any, in there, time from idea to filing. We sometimes keep statistics for clients that want that. And we try to put it in a spreadsheet, because this becomes talking points, or becomes easy to answer the question. The last two, the patent evaluation software, most firms have some variation of this, and they will run your patent application through that tool. And if they find something that comes out, they will correct it or update it before filing. There's a lot of false positive type things that come up in that, because patents are the language is so context based. Something looks like a typo, but it's not, right? But we can provide you with the output of that. If your attorney has the software and has run it through run your patent through that, and you have a good scoring, you can say that this is a well-known scoring tool, and our patents have this kind of score, right? And then finally, patentability opinion on prior art search. The question there, the metric was, it's just a binary. Have you done that, or have you not done that? If you've done that, they don't want you spending too much time or getting too much risk exposure for damages on it. But at the same time, they want to know that you're not going out there and doing something that somebody else has already done. So it's not so much you provide them with the opinion, but you say whether or not and how you judge that you're different from what others are doing from an IP perspective. Ralph, does that answer your question? Was that helpful?
Yeah, no, totally. I think I totally misunderstood this page, and I think the second go at it, I did get it, that these are the metrics that you want to be tracking. And then my understanding of the actual software component of this, the evaluation software, that's more as you're getting ready to go to file. This almost acts as a bit of a debugger to make sure that so it doesn't actually score the quality of the patents against the whole host of patents or the whole space.
That's right, but keep in mind that an investor may use this tool on patent applications that you have already filed. I guess that was my point, is that it's not just that the patent attorney does it, but some applicants file their own patents actually, pro se, or they file patent applications that are on, either the inventor has written or they've outsourced the writing of, and it hasn't gone through one of these tools. You should just be aware that if that's the case and somebody is using one of these tools to evaluate your portfolio for either investment or part of an exit strategy for M&A, they may be able to find things in your patent that you have not found.
So I have a question. We mentor a ton of startups through our program at UCR, and we end up referring out both IP work and corporate work to a number of different firms, mostly on the West Coast. And I was just curious how you guys work with startups. So do you do deferred deals where you will basically let a startup start working with you for some type of payment after capital is raised, as one example, or take some of the firms are doing like take a small piece of the equity in exchange for a 6-month deferral, that kind of stuff. Do you guys do any of that? Is your firm too small for that? Or how do you work with startups?
So I can tell you that we have a corporate group in our firm that probably has about 15 or 20 attorneys. And then our patent team is probably about 30, 35 attorneys. And we work with these emerging companies, and some do what I've typically done that works well. We ask for a retainer and we apply the retainer immediately to whatever work we do. I don't ask for evergreening of the retainer unless somebody falls behind on the payments. The retainer amount is not too high, and it's designed basically to make sure that they really want to file a patent application. They're really serious about it. But because I use completion billing, it's not an hourly or a monthly invoice. The invoice comes at the time of the filing, which might be 1 to 2 to 3 months afterwards, and then thereafter the invoice is payable in a certain number of months, like 2 to 3 months. And as long as my clients pay on time, they get a longer. The clients who pay on time get a longer. Like if a client pays on time for years, I'll give them net 90. But if a client is late on payments, I may require evergreening. So I kind of work it that way. And so what happens is these startups get a window. They get a runway. My risk is covered by the retainer, but they have a runway of sometimes 1 to 4 to 6 months before further fees are owed. Some of our attorneys have done equity. I typically haven't done that, but sometimes we're open to that. I think the thinking in our firm has typically been just to take a retainer and do completion billing, but we'd be open to discussing about it, certainly.
Okay, great. And then follow up just quickly to that is, do you guys do investor introductions as well? Do you have an investor network, VC network? Because a number of firms you work with do that for the startups as well.
I have to talk to my corporate folks. I typically haven't done that because I'm pure patent, I'm pure IP.
Right. Yeah.
But I think our corporate people do.
Okay.
Yeah.
Cool.
We can get you an answer on that. I think there's 1 or 2 corporate folks who are very active with the emerging companies. So yeah, we can get you an answer on that, Scott.
Great, thank you.
All right, thanks so much, Scott and Miku. So I just want to be mindful of time. We are a minute over here now. So unless if there's anyone else who's got a quick question, we'll go ahead and conclude it there. I do want to remind everyone that the final of the 3 sessions is going to be an hour long, and that's next Wednesday, March 24th from 1 o'clock to 2 o'clock p.m. So if you haven't already signed up for that one, please RSVP. It's going to be a great session. It'll give you a lot of time to ask a lot of these questions that we've seen over the past 2 sessions. So with that, I'll turn it over to Miku if he's got any closing words.
No, I would just say, let me stop share here. So I really appreciate all of you giving me time. I'll send the PDF over to you, Zach, to share. But now, if you have any questions, please show up next week, and we'll be happy to answer any. Feel free to send us an email, and we can also answer them that way. And I'm just really grateful for your time today.
Thanks
Thank
much,
you.
Miku.
Thanks
All
a
right.
lot.
Have a good day, everyone. Happy
Take care.
St. Patty's Day.
Bye.